Tree, you need to come and get the screen. We're in session in cause number 323774. The case is styled the state of Texas versus Tanya Drusilla Gonzalez. Let the record reflect that Ms. Gonzalez is present in court with her attorney, Mr. Wright Kimbler. Let the record also reflect that the state assistant district attorneys, Mr. Daniel Boyd and Ms. Julie Maxey, are also present. The record may also reflect that all the members of the jury are present in the courtroom. At this time, ladies and gentlemen, I will read to you the court's charge. The defendant, Tanya Drusilla Gonzalez, stands charged by information with the offense of assault alleged to have been committed in Jefferson County, Texas, on or about the 24th day of May of 2019. To the charge, the defendant has entered a plea of not guilty. I now give you the law that applies to the case. Our law provides that a person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. So that you may better understand the nature of the offense with which the defendant is charged, I now define certain terms and words. The term bodily injury means physical pain, illness, or any impairment of physical condition. A person commits acts intentionally or with intent with respect to a result of her conduct when it is her conscious objectives or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of her conduct when she is aware that the conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of her conduct when she is aware of but consciously disregards a substantial or justifiable risk that the result will occur. The risk must be of such a nature and degree that it disregards constitute a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the active standpoint. Upon the law of self-defense, you are instructed that a person is justified in using force against another when and to the degree she reasonably believes the force is immediately necessary to protect herself against the other person's use of unlawful force. A person is under no obligation to retreat to avoid the necessity of repelling or defending against attack or threatened attack. When a person is attacked with unlawful force, or she reasonably believes she is under attack with unlawful force, and there is created in the mind of such a person a reasonable expectation or fear of some bodily injury, then the law excuses or justifies such person in resorting to force by any means at her command to the degree that she reasonably believes such force is immediately necessary, viewed from her standpoint at the time, to protect herself from such attack or attempted attack. It is not necessary that there be an actual attack or attempted attack, as a person has a right to defend herself or her person from apparent danger as fully and to the extent as she would do or would she had the danger been real, provided that she acted upon a reasonable apprehension of danger, as it appears to her from the standpoint at the time, and that she reasonably believes such force was immediately necessary to protect herself against the other person's use or attempted use of unlawful force. However, the use of force against another person is not justified in response to verbal provocation alone. Now, if you find and believe from the evidence beyond a reasonable doubt that on the occasion in question, the defendant did intentionally, knowingly, or recklessly cause bodily injury to Thistle Wagner by striking complainant about the head and face with her hands, but you further find from the evidence, or you have reasonable doubt thereof, that viewed from the standpoint of the defendant at the time, from the words or conduct or both of Thistle Wagner, it reasonably appeared to the defendant that her person was in danger of bodily injury, and there was created in her mind a reasonable expectation or fear of bodily injury from the use of unlawful force at the hands of Thistle Wagner, and that acting under such apprehension and reasonably believing that the use of force on her part was immediately necessary to protect herself against Thistle Wagner's use or attempted use of unlawful force, the defendant did cause bodily injury to Thistle Wagner by striking complainant about the head and face with her hands, then you should acquit the defendant on the grounds of self-defense. Or if you have reasonable doubt as to whether or not the defendant was acting in self-defense on said occasion under the circumstances, then you should give the defendant the benefit of doubt and say by your verdict, not guilty. If you find from the evidence beyond a reasonable doubt that at the time and place in question, the defendant did not reasonably believe that her person was in danger of bodily injury, or that the defendant, under the circumstances as viewed by her from her standpoint at the time, did not reasonably believe the degree of force actually used by her was immediately necessary to protect herself against Thistle Wagner's use or attempted use of unlawful force, then you should find against the defendant on the issue of self-defense and find the defendant guilty of the offense of assault as alleged in the information. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, Tanya Drusilla Gonzalez, did in Jefferson County on or about the 24th day of May 2019, did then there, intentionally, knowingly, or recklessly cause bodily injury to another, namely Thistle Wagner, hereafter styled the complainant, by striking complainant about the head and face with her hands, and you further find beyond a reasonable doubt Tanya Drusilla Gonzalez was not acting in self-defense, you will find the defendant guilty. Unless you so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The fact that a person has been arrested, confined, indicted, or otherwise charged with the offense gives no rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. If it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have been or that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. You are the exclusive judges of the facts given, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. Now, the last page of this charge is the verdict page that should be signed by the foreperson. And it looks like this. If your verdict is, we the jury find the defendant not guilty, then your foreperson will sign on the top line. At the bottom, it says, we the jury find the defendant guilty, and if that's your verdict, then your foreperson will sign on the bottom line. Do we understand? All right. Okay, ladies and gentlemen, the jury will now proceed to closing. State, are you ready?
State's ready, Your Honor.
Defense, are you ready?
Ready, Your Honor.
Okay, Mr. Boyd, You have the right to open and close. And we'll give you 20 minutes and I'll be keeping time. You may proceed.
Well, we made it to the home stretch. I'm glad it's in the morning, not the afternoon. As you all know by now, we're here for the offense of assault. And in Texas, as we said, assault under the Penal Code Section 22.01, a person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to another. Now, with regard to that, we said, what is bodily injury? Well, it says physical pain, illness, or any impairment of the physical condition. We said that there's some things the state must prove, in this case, beyond a reasonable doubt, if somebody's going to be convicted of the offense. And in this case, I have to prove that in Jefferson County, Texas, the defendant, Tanya Drusilla Gonzalez, on or about May 24, 2019, intentionally, knowingly, or recklessly caused bodily injury to Thistle Wagner. Now, the burden of proof, just said, is beyond a reasonable doubt. Not beyond all doubt. It's not 100%. It's a reasonable doubt. It's not doubt based off of unreasonable arguments. Now, we talked about that there what I like to think of trial as a puzzle, putting together a jigsaw puzzle. Start off with a few pieces, not really clear what it is, what we have. But as you go along, you start putting those pieces together. And maybe there's some missing, there's a few missing, but ultimately you understand what is the picture, and you understand that beyond a reasonable doubt. You can get common sense. Now, I'll go back on this. Let's put the pieces together in this case. All right, there was testimony from Officer Jacob Froman of the Beaumont PD that on or about May 24, 2019, he was working as a patrol officer with Beaumont PD. He testified that approximately 9:47 p.m. he was dispatched to a residence located at 6745 Highway 105. He said that was in Jefferson County, Texas. So I think we got that first element in reference to an assault. The evidence showed that Officer Froman met with the complaining witness in this case at the Anchor Church. We had her testify that it was Thistle Wagner. You heard testimony from Officer Froman that upon meeting with her, again, he observed a laceration, that he called EMS after that to come treat her. And you heard him testify as to what Miss Wagner told him, that she had been assaulted, as well as she testified to that she'd been assaulted by the defendant, Tanya Gonzalez. You heard Miss Wagner state that the defendant approached her and began accusing her of a Facebook post, some kind of, they're calling her somehow from Facebook, I'm not really familiar with Facebook, but it led to an argument anyway, nonetheless, over the Facebook. Now, you heard testimony from the defendant that it was over, she accused Ms. Wagner of stealing the phone. Either way, there's an argument going on. And you heard testimony that Ms. Gonzalez then struck her in the forehead with her hand while holding a ceramic coffee mug. And that was testimony from Ms. Wagner, causing the laceration to the forehead. Now, you heard Ms. Wagner testify that she then said, I'm calling the police, and did in fact call the police, and went over to the Anchor Church there across the street. And there was testimony that no one else went over there to help Ms. Wagner. No one was with her. All of her supposed friends there. No one showed up. There was testimony that that the defendant said that she struck again Miss Wagner, and she was afraid that Miss Wagner was running toward her. Well, you didn't hear any testimony from Mr. Grider when he testified. He left out. He said he didn't say anything about her rushing towards her. He said she was waving her arms about and acting, he felt like aggressively, but she struck her because she was acting aggressive. He said she may have nudged her with her shoulder or something like going past her. But then you heard testimony from the defendant saying, yeah, she nudged me with her shoulder, but that wasn't when I struck her. That wasn't the part they caught, but she wasn't afraid. So even the defense's own witness, Mr. Grider, that they called up here, that conveniently never went to the police and gave a statement before him. They said we didn't contact him. He never came to give his statement to sort this out. Even he didn't mention anything about Ms. Wagner rushing towards the defense. Now, you heard that because we just talked about assault. And what we're really dealing with, I don't think you're going to have, and that's what I anticipate, you're going to have trouble with necessarily the assault. It's going to be the issue of self-defense that we're really going to be focused on. And I think by the other, defendant admitted that she struck it, that she intentionally struck it. It's assault causing the laceration, causing bodily injury. It's a cut. There was pain. There was testimony from the Ms. Wagner that there was pain. So I don't anticipate, based on that evidence that was presented in the defense's own admission that she did strike Ms. Wagner, that we're going to have an issue with that. That's up to you. You give how much weight you want to that evidence, but the defendant did in fact say she did strike, intentionally struck. Now, what she said was that she did that in self-defense because she was afraid. And I'll focus on that self-defense part after Mr. Kimber gets up and talks. And I'll come back and revisit that issue.
I use 6 minutes. Mr. Kimball,
Thank you.
you may proceed.
That place before?
Yes.
So, ladies and gentlemen. Law of self-defense is kind of more complicated or convoluted than you may think in Texas. And as far as the court's charge to you on that, this is a standard charge. It's given in every case. It's specifically drafted with this case. This is the charge, the standard charge that's given. I apologize that it's kind of convoluted and turgid. It's kind of difficult to understand, but I'm going to attempt to go through it with you and just maybe clarify some of the things about it. Because Mr. Boyd's right, this case is about self-defense, and it's about credibility, to the extent credibility of witnesses. Because there's no question Ms. Gonzalez hit Cecil Wagner, no question about that. All right, so there's a strike, there's pain, so there's an assault. But is it self-defense? So that's the question. Has the state proved to you beyond reasonable doubt that it's not self-defense? But before you can say it's not self-defense, you're gonna have to understand what is self-defense. And the court's gone through in its instructions in section 3 and kind of giving you an idea or a roadmap to what self-defense is. So you have to know what it is before you can say whether the state's proved that it doesn't exist beyond a reasonable doubt. So what the court's told you is that a person has to reasonably believe she is under attack with unlawful force. Now, it's a reasonable belief. Whether they actually are or not, it's just whether you reasonably believe under the circumstances. If they not, is the belief reasonable that they were? And this is all in section 3. So the person has to reasonably believe that they're under under attack with unlawful force, such that in their mind, the person has a reasonable expectation of fear or some bodily injury, then the law excuses or justifies such person in resorting to the force that they reasonably believe is necessary, immediately necessary, viewed from their standpoint, to protect themselves from the attacker. That's pretty straightforward. You can understand that when the circumstances are such that a reasonable person reasonably believes that they're about to be under attack, then they can use reasonable force to protect themselves. Now, it's reasonable force, it's not unreasonable force. You keep hearing this word reasonable, yeah, that's the idea that, if you think somebody is about to punch you, then it may not be reasonable to shoot. Okay, that's kind of the idea there. Is it reasonable force that's used to protect the person from their perceived attack, from the perceived attack. It's not necessary that there's an actual attack or attempted attack. It's not even necessary that there actually be an attack occurring on the person using the force, because a person has a right to defend themselves from apparent danger. And if it's apparent, it's not real danger, but it appears to be unlawful use of force, then you can protect yourself by using reasonable force. And again, the court says apparent danger, and it's the same as if fully to the same extent as they would have the danger been real, provided that she acted upon a reasonable apprehension of the danger as it appeared to her from her standpoint at the time. So we know that it doesn't even have to be a real danger. It just has to be an apparent. Now, this is basically, that's basically the law of self-defense, and that's in section 3. Now, once evidence of self-defense has been introduced, then it becomes justified that the court has to charge on self-defense. And it then becomes the burden of the state to convince you beyond a reasonable doubt that the person who is asserting self-defense, in this case, Ms. Gonzalez, was not acting under self-defense on all of these elements. So before you can convict in this case, you have to believe beyond a reasonable doubt that Ms. Gonzalez was not acting reasonably under these circumstances. In other words, when she punched Ms. Wagner, she wasn't reacting reasonably. First of all, that was an unreasonable amount of force. But further, that she was not acting from the perception of apparent danger of her being attacked. All right. You got to believe that beyond a reasonable doubt. If you have a reasonable doubt about it, then the verdict's not guilty, because they have to convince you beyond a reasonable doubt that it's not. And again, that's intellectually kind of hard to do, because you have a law of self-defense, and you flip it around as, well, they don't have to prove, you don't have to prove self-defense. The defense doesn't prove self-defense. The state has to disprove. So you're flipping it around, which is kind of a hard intellectually to do that, right? That they got to now disprove. It's not that we have to prove it, they have to disprove it beyond a reasonable doubt. So did they disprove to you, to your mind, on this evidence, that Ms. Gonzalez was not acting reasonably in apprehension of an apparent danger of Ms. Wagner attacking? You can think, she probably wasn't, but that's not beyond a reasonable doubt. Again, it's the same reasonable doubt standard that's applied, beyond reasonable doubt standard that's applied to any criminal case. All right. So what's the evidence that we have? All right, now it comes down to the credibility of witnesses. What do you believe? What do you don't believe? What evidence do you want to concentrate on? What evidence do you want to discount? Because you have conflicting testimony. Now, the first observation I would make, as far as the defense witnesses, we had 2 witnesses, that if Mr. Grider's testimony lined up in every way and was consistent in every detail with what Ms. Gonzalez testified to after 2.5 years, the state would be saying to you, ladies and gentlemen, that's a sign that you shouldn't believe them, because they got together beforehand and got their story straight before they testified. If everything lines up completely and they agree. The fact that there's differences between their testimony, divergences, actually lends credibility to what they're saying. This is 2.5 years ago. To think that they're going to line up exactly on what the testimony is unrealistic. If it does, then you should have questions that they got together and agreed to what they were going to testify, which I don't think is the case. Because there are differences. But what they're consistent in is that Ms. Wagner was acting in an aggressive manner. She was acting aggressively. This isn't a situation where Tommy Gonzalez goes over to Ms. Wagner's house and starts problems with her. Ms. Gonzalez is already at this house. Ms. Wagner's the one that's driving up. She's the one going to somebody else's house causing problems. If she had problems with Ms. Gonzalez, when she saw she was there, she should have left. She should have even stopped. She's the one that's initiating this confrontation, not Ms. Gonzalez. Ms. Gonzalez isn't driving over to Ms. Wagner's house. When they get there, when Ms. Wagner gets there, you have testimony that, again, it's consistent that there's some sort of confrontation. Now, what Ms. Wagner do? Again, this goes to her credibility, right? She says she's, they're talking, and Ms. Gonzalez hits her with a coffee cup. It's unprovoked. She does it spur of the moment, no provocation from Ms. Wagner. And she gets this laceration. That's the state's witness's testimony too. Now, as far as evaluating the credibility of being hit with a coffee cup to Ms. Wagner's offer, I want you to recall the beginning of this case when I stood up with Ms. Gonzalez and she entered her plea of not guilty, right, to the information in this case, the charging information. What is the information? What are the allegations filed by the state allege? All right, and evaluating Ms. Wagner's credibility about getting hit with a coffee cup. The state alleges that, we'll just read the whole thing to you. In the name and by the authority of the state of Texas, goes out the undersigned Assistant Criminal District Attorney, Jefferson County, Texas, on behalf of the state of Texas, and presents into the County Court of Law, Jefferson County, Texas, that Jefferson County, Texas, Attorney Drusilla Gonzalez, here after selling defendant here before about May 24, 2019, did there intentionally, knowingly, and recklessly caused bodily injury to Fiscal Wagner, here after selling the complainant by striking complainant about the head and face with her hands. That's what they're saying. They're not saying she was hit with a coffee cup. That's not what they're alleging. They're alleging hands. Now, who testified that they used their hands to hit Ms. Gonzalez? Was it their witness or was it Ms. Gonzalez? Who's testifying consistently with the allegations that the state of Texas are making? It's Ms. Gonzalez, not their witness. They're the ones that made the allegations. They're the ones that said she was struck with her hands. And now they're saying she was struck with a coffee cup. Their allegations lend credibility to the defense witness, not their witness. That's something you can consider. In any case, you heard from Ms. Gonzalez that at the time she punched Ms. Wagner, which she doesn't contest, that she was acting under the immediate apprehension of unlawful force being directed at her because Ms. Wagner was lunging. Moving towards her in an aggressive manner, however you want to say it. I think lunge describes it, lunging aggressively at her to attack her. All right. Mrs. Wagner didn't hit her, but she was lunging at her in an aggressive manner. Now you have to wait, ladies and gentlemen, does the law require you to wait to be hit or to be tackled before you defend yourself? No, that's the apparent danger. That's what the court's instructed. You don't have to wait to be hit. Self-defense, you can throw the first punch. You're allowed to do it. If it's reasonable, you're acting reasonably, it's reasonable force, and you're acting reasonably in response to the apparent danger of another person's use of unlawful force. That's exactly what she did. She punched her one time, and she got her forehead. Now, you may say, okay, how is it possible for somebody barehanded to punch somebody in the forehead and cause a laceration, a break in the skin? Well, I would represent to you that it is possible. If somebody has those bony knuckles, they're using sufficient force on that thin skin of somebody's forehead, that, yeah, it's entirely. possible and capable that that's the injury that's going to be caused, because that's what's happened. Those of you that may follow sports, whether it's boxing or MMA, you see a lot of times where people get padded gloves in a fight. People get cut across the brow. That's why they put Vaseline on people's foreheads before a fight to keep the punches sliding off so the skin doesn't get split. I asked Ms. Gonzalez, well, you don't think it was a ring you were wearing? Maybe that, no, I didn't have the ring on. That was I know. All right, she could have said it was a ring. She could have testified in a way that would have been more helpful to her. She didn't. She told you the truth. She punched her one time, and then the fight was over. And then Ms. Wagner is the one that's initiating the call to law enforcement to file charges. I would suggest to you that that's probably what's going on from the beginning, that she's looking for a way to perhaps provoke Ms. Gonzalez so she can file charges. Because if you look at the two of them, I would think that in a real fight, Ms. Gonzalez is probably going to be the one that's going to come out lose the end of that compared with the two of these individuals. And Ms. Gonzalez certainly is not going to be trying to initiate a fight with Ms. Wagner. Just looking at the two individuals involved. Ms. Wagner, obviously is telling you she has combat sports experience, boxing, taekwondo, whatever it is. And it wouldn't be a good idea for Ms. Gonzalez to be picking a fight. But Ms. Gonzalez knows that. She was defending herself. Now, do I have to prove to you she was defending herself? Do I have to prove that? Is it my burden to prove that to you? No, he's got to disprove beyond a reasonable doubt. I would suggest to you that there's at least a reasonable doubt whether Ms. Gonzalez was defending herself, so the verdict should be not guilty. You can look at the evidence, make your own decision, but again, it's not up to me to prove to you that she was acting in self-defense. He's got to prove it to you beyond a reasonable doubt that she wasn't, and they haven't done that. Last thing, when you go back into the jury room and begin your deliberations, the judge has instructed you that it's your obligation to see that justice is done in this case. I would simply suggest to you that that's not a collective responsibility that you have. It's an individual responsibility. So if you go back and you all discuss the case and deliberate in good faith and you can't come to a unanimous decision, that's not a failure on your part as a jury to be unable to reach a verdict. It's only a failure if one or more of you give up what you think is the correct vote, whether it's guilty or not guilty, simply to return a verdict. That you feel pressure to return a verdict, so you just vote one way to return a verdict, and you give up what you think is what the proper result is. It's not any kind of a failure if you can't reach a verdict. You just have another trial with another jury. Okay. All right. I thank y'all for your presence here and your time to vote in this case, and look forward to seeing you later.
Mr. Boyd, you have 19 more minutes. Well, 14 more minutes.
Thank you, Your Honor. Now, Miller versus State says an accused has a right to an instruction on a defensive issue on any defensive issue raised by the evidence, whether that evidence is weak, strong, unimpeached, or contradictory, and regardless of what the trial court may think or not think about, may or may not think about the credibility of it. So if someone raises anything ridiculous, it still has to be an instruction on it. Now, Texas Penal Code section 9.31 dealing with self-defense, it says, except as provided in subsection B, a person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against these others' use or attempted use of lawful force. And as Mr. Kindler said, I like to focus on that word reasonable. He said that's what it comes down to. Whether or not it was reasonable, whether she acted reasonably, had a reasonable belief that she was afraid, and as well as the credibility of the witness. I agree with that. Now, as far as reasonable belief, it means a belief that would be held by an ordinary and prudent a person in the same circumstances as the actor. Reasonable belief, ordinary and prudent person. Now we're going to look at Giuliani versus state. It says, once the defendant produces that evidence, the state bears the ultimate burden of persuasion to disprove the raised defense. So that's our burden to disprove it, but we don't have to produce any other evidence. It only requires us to prove our case beyond a reasonable doubt. So the state's not required to produce any more evidence. In fact, we're going to use the evidence and put those pieces together based on the evidence that we do have that was presented here. Now, as we just read, with regard to self-defense, the burden of persuasion did not require the state to have any. So let's put these pieces together. And there was testimony by Ms. Wagner that on the day of the incident, she left work at Walmart. She gets a call from a Leslie Johnson, who she says is the girlfriend of Rob Grider, the defense's witness that they had testified, to come over there, that come hang out, and they were going to go fishing that evening. So she gets over there. She testified that she gets to the house. She pulls up on the left side where she drew up there, that she noticed Miss Gonzalez was there. And she admitted, she said, there's some things at that time, Mr. Kindler asked me, you didn't like her. She said, no, there's things I like about her, Miss Gonzalez. Oh, there's things I didn't like about her. But you know who who said they didn't like her and didn't get along with her? That was Miss Gonzalez. She's the one that had the motive. Now, Mr. Grider testified that he believed that, Ms. Wagner testified that she was friends with them. And Mr. Kindler had her admit that based on a relatively short time, that they were just acquaintances. And that was it. Nobody came to help her. In fact, everybody fled. Everybody left, according to them. Now, there was testimony, Ms. Gonzalez. She said, I didn't have to. She left. Is that what a reasonable, let's get on that word reasonable. Is that what a reasonable person does? Common sense tells you no. Someone else said they're calling the police because you just tried to come at me. They call them. I'll be the first one. In fact, I got other witnesses here. Right? But no, we don't hear this all the way until now. But actually, the victim, Ms. Wagner, she did call. And she did say evidence of the game. Mr. Kindler, I know he's done some martial arts. People who do these things, they understand their hands are dangerous. And if you attack someone else, you can cause serious injury to that person. That's when I say that she exercised great restraint, Ms. Wagner did, by not being attacked. And then she did. She said she laughed about it. Yeah, you're going to be in trouble now. You just went too far. You struck me in the head. I've got a gash. I'm bleeding. And we're arguing. They didn't give you a right. I'm flailing my arms in the air arguing with you because you just accused me of theft, is what the defendant said. And it's kind of ironic. The defendant was the only thing said about anybody taking anything, stealing anything, the defendant. She said she stole. Mr. Grider testified there were no injuries on the defendant. The defendant testified there was no injury, that she was never struck by Ms. Wagner. Now, is that reasonable? You can make a reasonable inference. If I'm somebody that's trained, yeah, Evander Holyfield there, we're in disagreement. So Evander Holyfield comes over there, and I think I'm just gonna, what am I gonna do? I'm afraid he's acting aggressively, right? He was saying things aggressive. She couldn't remember what she was saying. She couldn't remember what Ms. Wagner said. That was unclear what she was saying. I'm just very, very clear though that she had stole something and that she ran it. Now afterwards, why didn't you call the police? Why didn't you stay around for the police? Well, I don't really remember that. Well, that's convenient. To have selective memory. That's what I like to call it. Have a selective memory as to what you can recall and can't recall. So if I do that, is that reasonable that I'm gonna tell, someone with professionally trained experience, I'm then accuse them of theft? I'm feeling threatened. They're acting aggressive. So yeah, what is a reasonable person gonna do? Are they gonna then accuse them of theft? I think that's what I'll do. Then next thing I know, I'm gonna feel like you're threatening. I'm gonna punch you in the forehead. I can tell you the consequences of that. It's probably not gonna be good for me. But yet, the defendant didn't have a mark on her. That's because people in those positions know, people that are trained with those skills know that if they then react that way, if everyone that runs up to a professional fighter like that, or someone that's trained enough, and has someone jaw jack and run their mouth, if they put their hand on it, they're really severely going to hurt that individual. And that's why they don't do that. And the person who was reasonable and prudent in this situation was Miss Wagner. She was prudent by calling the police, doing what she should have done. Now, maybe, yeah, it was an argument. There may have been some ridiculous things said. That doesn't give you the right to put your hands on somebody else. That doesn't give you the right to split their forehead open. Mr. Grider, he comes out of nowhere to come testify. When asked why he didn't stay around. Well, he didn't remember until I asked him about that warrant. Oh yeah, got to mention that. That's why I ran off. But I left my friend. He was good friends with him. That's according to him. Okay, he's good friends with he'd known her for quite some time, Miss Wagner. But yet he was nowhere to be found. And you didn't hear anything from Mr. Grider on Miss Wagner rushing at the defendant. There was nothing about that. In fact, big point, we're talking about, was she reasonably afraid? The defendant said she wasn't afraid when she said Miss Wagner nudged her with her elbow or was wriggling her arms about. She said she rushed at her and then couldn't remember anything else. That's all she could remember. To bring up self-defense. That's what she could remember. But Mr. Grider didn't remember that. But he just said she was acting aggressively. Acting aggressively. She knew, again, that she was had professional boxing skills. Yeah, she went ahead and accused her of theft. Ain't gonna sit there. And then now, again, not hang around. Is that reasonable? You're not gonna hang around? Calling the police, not gonna hang around. Or reasonable, somebody who's going over there starting trouble to hang around and call the police. No, she was called over there to go fishing. That was a testimony. There was a lot from Mr. Kindler about that fishing pole. But even Mr. Grider said, yeah, we were going fishing later that evening. That's what lined up. The facts and the evidence. Now, again, beyond a reasonable doubt does not mean beyond all doubt. And it does not mean doubt based on unreasonable argument.
Mr. Boyd, you have 5 minutes.
Person. Thank you, Judge. Now, you may be thinking, Mr. Boyd, I believe the defendant's guilty. She admitted it, and I don't believe she acted in self-defense. But I just don't think I could you talk about jail time and that, you talk about, that's not for this part of the trial. You think she won't be probation, that's for the punishment. We're simply talking about guilt, innocence, right here. And whether or not she acted in self-defense. And I present to you, ladies and gentlemen, based on that reasonable person. She did not act reasonable. And that's why she didn't hang around. That's why she didn't go to the police and get the police. That's why none of that came up. And that's why Mr. Grider didn't. None of them hung around, the friends. And yeah, Miss Wagner called the police. She did. But she knew she was in the right. She knew she didn't rush at her. And in fact, you think Miss Wagner getting punched in the head is going to stop her from then, if somebody punches them in the head, they're gonna let it go. Somebody trained as a professional fighter, somebody punch Evander Holyfield, it's about to be bad for me. No, they're exercising restraint, and that's still assault. We talked about victims during board hour, come in all shape, sizes, all socioeconomic statuses, race and genders, and victim. And just because, I'll say it, just because the victim may look a little rough around the edges, doesn't mean she's not a victim. It doesn't mean that this didn't occur. In fact, the only one, and it seems like every one that Miss Gonzalez run across, she meant to shoot somebody. Everybody else had injury, but nope, Miss Gonzalez hadn't had any injuries. So every time I can just claim this self-defense, throw that up there, throw some unreasonable argument up there, and it does have to be presented to you. But that's why we have these other facts and evidence. And if you don't believe that that was reasonable, then I ask you to find her guilty.
3 more minutes.
And I don't know about y'all, we're not here saying, and I'm not saying Ms. Gonzalez is a bad person. I don't think the victim in this case, Ms. Wagner, said she said every good thing, bad. And you say, we've been here for 3 days, boy, on assault. People arguing, she struck her, she committed that. You're right. And you know why? Why is assault important? Class A assault. Because assault can lead to other assault. If the victim would have retaliated and struck her using her skills and injured her severely, we'd be in felony court. We didn't. And she didn't. She held great restraint and did not do that. That she did the reasonable and prudent person was the victim. She called the police.
2 more minutes.
And again, if you are worried about that, if you're worried about the probation doing, that's for punishment. It's not for this. And I asked you about the beginning, is crime a problem in our community? And y'all answered number 3 on those questions. We said, is crime a problem? You said, most people answered too many people are committing crime. Well, ladies and gentlemen, you are the last link in law enforcement.
Objection, that's not true. They are not the last link in law enforcement. They're an independent body that determines guilt or not guilt in the criminal justice system. The jury is not the last link in law enforcement.
Ladies and gentlemen, jury, questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. The arguments are not evidence, and you should give the arguments only the considerations you feel they deserve during the evaluation of the evidence. Okay.
Ladies and gentlemen, I ask you to send a message to the police, district attorney's office, and most importantly, to this community, that crimes like this not going to be tolerated. It can lead to other crimes. Think about it. DWI, many people may not think DWI misdemeanor is important until someone gets killed as a result of driving while intoxicated. Same thing with assault. You may not think it's important, but it's very important.
You have 1 minute.
I don't know about y'all. I'm not here saying she's a bad person. We're here saying to own up to your mistakes and that you gotta be held accountable. When I was growing up, I made some bad decisions. Took some bad action, but you know when I learned the best is being held accountable for those actions. And that's the best lessons I learned, was from being held accountable for those actions. And I asked y'all to find the defendant guilty. And I thank y'all, and you didn't waste your time. I want you to know how important it is for these assault cases. And it's been 3 days, and I appreciate that very much. And I thank y'all again during these times.
Okay, ladies and gentlemen, the jury, at this time, all the evidence, the court's charge, and the closing arguments of counsels are before you. Now, before we allow you to deliberate, there's a matter that the court must take up, and that matter is the alternate. One of you is an alternate on the case, and what that means is, if you're alternate, you cannot go into the deliberation room and deliberate. However, you would have to either wait in the back or in the hall while the deliberation is going on. Now, if something happens to one of the other jurors, then you will be allowed to participate in the deliberation. And the alternate in this case is Mr. James Raymond Jr. Okay, that's the alternate. So at this time, ladies and gentlemen, jury, we're going to be in recess to give you, Mr. Bailiff, would you please hand the charge? Wait, just hold on to the charge. Now, ladies and gentlemen of the jury, because of the COVID protocols, we have been allowing the jury to deliberate in the courtroom because it's more space. And what we'll do if you choose to do that, now we do have a jury room back there. If you decide to, if you want to deliberate in there as well, but under the COVID protocols, we've been allowing the jury to deliberate in the courtroom because it's more space. Now, at this time, the lawyers and myself, we're going to clear out of the courtroom. The doors will be secured. You will have access to the jury room back there, as well as the restroom and the area that we have coffee in. Now, there is a blackboard in the jury room, and it tells you that if you have a question, you ring the bell once, and there's a bell on the back wall next to the door. And if you have a question, you ring the bell once. If you have a verdict, you ring the bell twice. Okay, so we're going to clear out of this courtroom to allow you to start your deliberation process. Now, ladies and gentlemen, jury, prior to starting, if you want to take a break, because we have been going a little long for about an hour, you can take a break and then you can start your deliberation process. Okay, so what we'll do is we'll be allow you 15 minutes to take a break for 15 minutes, then you can come back in and start your deliberation. Okay, at this time we'll be in recess. Okay, Ms. Perazo? Ms. Perazo, I see you. Okay, I see that you're on Zoom.
Yes,
Okay, currently
sir.
I know that you have a case on the court's docket, Leela Daigle, and I guess that's what you're calling about, is that correct? Okay, you're breaking up. Ms. Perazo is breaking up.
Sir, I believe I was Daigle. Yes, sir. Yes,
Okay.
sir.
Okay, that's a case that's on our jail run. We're currently in trial, and once we get out of trial, we're gonna start the jail run because we only have one bailiff. Hers is at 1:30? Oh, the court coordinator just informed me that your case is at 1:30. She just got off the phone with Miss Catherine.
Your Honor. Okay, my calendar. I just want to make sure I'm not missing anything.
Okay, yes, it's at 1:30 at
Okay.
jail. Okay.
Okay, perfect.
All right.
Okay, thank you so much.